Hi, welcome to Legally Speaking. I'm your host, Sophia Haynes. Legally Speaking is a public service of you and the law. It is meant to be an educational program. If you need the services of an attorney, make sure that you hire a licensed attorney. Today we're talking about child support, abandonment, and the law of legitimation in the state of Georgia. And we have two guests, Miss Monica Freitag and Miss Pamela Ritchie. Welcome, ladies.
Thank you.
Thank you.
Monica is the founder of Hanrahan Freitag Family Law LLC. She's been practicing 9 years exclusively in the area of family law with a focus on victims of domestic violence. Pamela Ritchie is the founder of Kids Needs Dads Too, whose goal is to raise awareness of the legitimation laws, and she's also a foster parent. Welcome again, both ladies. I want to jump right into it because we have so many individuals that have questions about child support. Why do I have to pay child support? Why did this person get custody or that person getting custody? Even whether I'm in a marriage situation or I'm a single parent and we're both unwed parents having a child. Monica, can you tell us what is the law around who gets child custody in the state of Georgia?
There are some guiding principles, whether you are married or unmarried, when you're at the point of the judge having to decide child custody, who a little person is going to spend the majority of their time with any given week. Mm-hmm. The judge looks at a very broad standard, which is the best interest of the child.
So does that apply whether we are married when we have the child and we're now maybe divorcing, or we just two single people, unwed people that have a child?
A little of both. Married couples are both considered legal parents of the child, so it's by operation of law, meaning it happens instantaneously. You are both parents, so the judge is trying to decide, now that you're separating, where the child should spend the majority of their time. If you're an unmarried couple, when your child is born, the child is born with only one legal parent, and that is the child's mother. The father needs to go through a separate process called legitimation, basically raising his hand and saying, I want to be a part of my little person's life.
Okay, so we'll talk about that. Go ahead.
Okay, and then step 2, after you legitimate your child, would be determining the best interest and where the child's going to spend the majority of his or her time.
Okay, so you were talking about the best interest and how that's determined. So what does the judge look at to determine the best interest of the child? What exactly does that mean in layman's terms?
It's very, very broad. And in layman's terms, it's sort of what we all consider, what's in the best interest of kids, to be involved in extracurriculars, have their medical needs met, in general, being close to their siblings. It's very broad. But I brought some notes about what the statute actually directs as factors for the judge and court to consider when deciding best interest of a child.
Let's talk about that. So what are some of those factors that the court looks at?
One of the big ones is the bond that the child already shares with a parent and with siblings. Another is the parent's capacity to give love and affection, which we hope all parents are able to do. Mm-hmm. The input the parent has already had into rearing the child, things that go into rearing, education, medical needs, extracurricular, and their faith.
Well, let's talk about, all that sounds like it can apply to either parent. So what am I looking at practically, or the court looks at practically, determine how it falls on one side or the other?
You're basically, you can't do it because they're not fixed objects. It's basically like a teeter-totter. Which way leans just a little bit more towards one parent or another? In the 70s, Georgia became a gender-neutral state. There used to be a little bit of a shift towards moms being primary caregivers of kids, but now it's completely gender neutral, and you're just trying to see who has a little bit more of that good stuff that they can provide a kid.
Okay, so what are some of those other factors we were talking about?
Some of the other ones, your stability, and the court really specifically wants to look at financial and sort of emotional stability. Have you been in the same residence for a length of time? You don't have to be rich, but you do have to be able to provide the basic needs for your kids: food, clothing, shelter.
Okay.
Your physical and mental health are factors to consider. Involvement in school, extracurricular, and religious faith. Your schedule. Do you work third shift? That's going to create some challenges providing for your child, but it can also create some opportunities maybe in that second shift time, the 3 to 11, maybe you're able to provide a little more care then.
Okay.
The court also looks if there are allegations of abuse, violence. Those are factors that go against the best interest.
Well, do we see that a lot in divorce proceedings, though? How much weight will a judge give to that?
If there are allegations of physical abuse to a child, extreme weight goes to that factor. Fortunately, it doesn't come up too much, and the state intervenes if there is an extreme violence against a child. Another thing that's very unique to Georgia is 11 to 14-year-olds and children older even can elect. They can say, I'd rather spend the majority of my time with my dad. And the court needs to consider that election by the child when considering best interest. Because if you've got a 16-year-old who doesn't want to be at mom's house, the court doesn't think it's necessarily in her best interest to be running away.
Oh, so they give a lot of weight to what the child wants to do.
Once the child is 11, we think about it. We consider it a little. When the child's 14, it does have a lot of weight.
Wow. So what are the different types of custody that a parent can have?
It is as creative as the couple themselves and the family can make it. There are 2 types of custody that the court considers. Legal custody, that's who makes decisions about children. And 95% of the time, it's joint legal custody.
So what does that mean?
It means parents have got to talk. You've got to discuss big issues for your kids together. And big issues, again, extracurricular, religion, education, and medical care. You've got to talk about them. And then typically the primary caregiver, where the children spends more than 50% of their time, makes the tie-breaking decision if the parents can't agree.
Oh.
Joint legal custody also means that both parents have direct access to medical and school records, meaning they don't have to depend on the other parent to give them a copy. They can just go to the school and ask for school records and whatnot.
So do we need to file something with the school to let them know that I'm also a parent and that I'm entitled to this information, just in case I have somebody that may not want to share that?
Yes. Yeah. And schools are getting more and more savvy about looking for custody orders, divorce decrees as to which parents or either parent is entitled to information. The other type of custody, to go back to it, is physical custody. And that's physically where children spend their time. And that's where I was talking about creativity. Some families do, a new trend is a 2-2-5-5 schedule. So Monday...
2-2-5-5. Okay.
2 days a week, typically Monday and Tuesday with parent A, Wednesday and Thursday with parent B, then Friday through Sunday alternates. So what ends up is you get 2 days with mom, 2 days with dad, 5 days with mom, 2 days with dad, 5 days with dad. It works. Just trust me. Monday and Tuesday always in one spot, Wednesday and Thursday always in one spot, and then you alternate the weekends. It's a way to achieve a 50-50 schedule without kids having to be away from their other parent for a whole week at a time.
So how does that not create some instability with the child moving around a little bit? Does the courts favor that type of situation?
The courts really favor parents making a choice that they think is best for their child. So if you want to try this kind of schedule, and the child psychologists who work in child custody and this area of the law say some kids can adapt to a normal pretty well. So it can work, but it does require a lot of interaction, a lot of exchanges, a high level of communication. But courts probably not so inclined to impose it on a family, but are very happy if a family says this is what we want to try, to endorse it and turn it into a court order.
So how much weight does the court give to the parents if they come to an agreement themselves?
Lots and lots of weight.
Great. Okay.
Yes, that's the preference.
So it's better if we can just decide this amongst ourselves.
Correct. But knowing the law and what the judge would ultimately look at can help direct your decision-making process as you're coming to an agreement. Because if you know the court really does favor moms and dads both being involved, which is what your charity goes to encouraging, you know that when you sit in that meeting and you're trying to work out your schedule with your soon-to-be ex, it can drive how you make your decisions.
So is the final decision with the court, even though we agree?
Correct. The court has veto power. The court reviews each and every, it's called a parenting plan that couples submit.
Okay.
But in 9 years of practice, I've only seen 2 rejected. And those were people who came up with very, very complicated plans, and in the judge's opinion, it wasn't going to be feasible. But that means that 95, 96, 97% have just flown right through.
Wow. Okay, so let's shift gears a little bit. We've talked about child custody. So we know that either you're doing a 225 or you're doing half here and half there. Okay, so how does the court determine child support for the child? That's the subject of that proceeding.
Okay, it's a big deal, especially here in Georgia. We have a new child support calculator that went into effect in about 2007, 2008. So there's still a lot of families whose child support was established under the old standard.
Okay.
The new standard, you go to a calculator. Both mom's income and dad's income are put into, it's a spreadsheet, and they proportion it to their income, share what the Georgia State Legislature considers a couple at their earning level. So let's say as a couple you make $4,000 a month. The legislature has picked an arbitrary number that says a couple earning $4,000 a month would spend X amount on their child. You look at your 2 incomes, proportionate to your incomes, you each pay a proportion of that little amount. It's complicated. You just go and you fill it in on the calculator.
Okay, so are other that's why you're the lawyer.
Yeah.
Okay, but what goes into that calculation? We talk about insurance or typical housing costs. What goes into that?
Just a couple of things. The legislature hired actuaries to try and be as all-encompassing as to what goes into the total figure. So things like housing, electricity, all of the basics to provide for a child are there. Food, clothing.
Okay.
It's all considered in there. Things that were pulled out because the actuaries decided it was so dramatically different from family to family is the cost of premium for health insurance. That's put in as a separate line item, and it too is divided proportionate to each party's income. And then extraordinary, I was trying to think of the word, extraordinary extracurricular expenses. So if your child was into, say, horseback riding or traveling soccer or baseball team, that gets really pricey really fast.
So you can put that in as well.
And it becomes an extra amount that both parents contribute to. But basic extracurriculars like a school swim team, that's already factored in.
Like in childcare, I think that's
childcare. Thank you. I forgot.
That's tuition by itself.
Work-related childcare expenses, and that work-related is an important distinction. So childcare, so you can go to the gym. No, that doesn't get factored in. That's something you'll accrue when your child's with you. But work-related childcare expenses, so daycare while you go to work, after school care while you're at work, those two get factored in and divided proportionally between the parents.
So can a parent say, I forego child support? I don't want any child support from him or from her. Can they give up that child's right to child support?
No. It is the child's right and the state's obligation to make sure that both parents are supporting that child. Now, I won't say that couples make agreements a little outside of it. However, no, a mom or a dad cannot say, I don't want the money, because that money isn't for you, it's for your child.
Okay, well, we're going to take a break here. And when we come back, I want to talk about the whole issue of legitimation, and can I be required to pay child support even though I don't have any legal rights to this child?
Oh, good topic.
So we'll be right back in a couple of seconds. You are tuned into Legally Speaking, a public service of You and the Law. You and the Law is a nonprofit whose mission is to provide legal information and legal resources to empower you in your legal affairs. If you would like to have a question answered or a topic featured on Legally Speaking, feel free to contact us online at www.youandthelawtoday.org. You can also sign up there on our website for our mailing list, as well as follow us on Facebook and Twitter. Remember, with every right comes responsibilities, so know your rights and accept your responsibility. Welcome back. We're talking to attorney Monica Hanrahan Freitag and Pamela Ritchie about child abandonment, child support, and legitimation. Now, ladies, before we left, we talked about child custody, child support. I want to jump into the law of abandonment. We have a special law in Georgia, and I would highly recommend that you go and look at your state's laws. This is a show that's on the World Wide Web, but we wanted to bring some exposure to the whole topic because all states deal with it. But in Georgia, they have a special law of abandonment, and I can remember as a prosecutor, I think sometimes parents might have got a little frustrated with the child support system because it seemed to go a little slow. So they would jump automatically into child abandonment. So can you tell our audience what exactly is the law of abandonment in the state?
Certainly. Child support recovery is a civil practice. Civil meaning the consequence is some sort of financial consequence, not jail. Abandonment, the consequence is jail. In Georgia, if you fail to support your child born either in wedlock or out of wedlock, leaving them in a dependent state, that is, without their basic needs fulfilled, food, clothing, shelter, you can be prosecuted for a felony, punishable between 1 and 3 years in jail. Okay, so it's serious.
It's pretty serious. And I heard that there is a misdemeanor side and then there is a felony side of it. So can be very serious, and I can remember sometimes wanting to use that to kind of coerce the other parent to go ahead and pay that child support itself. Okay, 2 people not married, and I guess you know a little bit about this, Miss Ritchie, and we've all heard the saying, mama's baby, papa's maybe. If I'm not married to the person that I had a child with, what rights does the father have to that child?
Absolutely none. None. You have only one thing, which is an obligation for child support, but you do not have a right to the enjoyment of your child until you legitimate.
And have you had some experience with that, Miss Ritchie? Any examples of anything happening with your organization?
Well, not exactly that. I mean, because your right to your child you may not have unless that mom gives you that right to your child, and that means that the mom can take that right away whenever she wants also.
So have you seen it happen where somebody have a child and not have the rights that they thought they had to that child?
Well, I actually have a relative who had a child born out of wedlock, and the mother of the child died without a will. And he was not given custody of his own child because he had not legitimated, and the mom didn't have a will specifying that he should have custody, and he had a relationship with his child.
Oh, wow. So it didn't automatically go to him even though he was the father and involved in the child's life.
Correct.
So, Monica, tell us about that process. That's important.
The legitimation process is in Georgia, and it's the way you sort of, again, raise your hand and say, I want to be recognized as an active and involved part of my child's life. You file a petition in the county where the mom lives, basically say, I want to be involved in my child's life. Legitimation, it will be granted unless the mom can show it would absolutely not be in the child's best interest for you to be recognized as the legitimate dad.
So do we have to have the mother's permission in that process?
It's not so much her permission. Now, if she grants her permission, the process will go much smoother because the court's really just signing a consent order. Everybody agrees. You don't have to have a contested hearing. But if mom doesn't want to agree, the court will order it essentially over her objection, unless she can show it wouldn't be in the child's best interest. And it's a different standard. It's very, very high. There's a presumption that having both parents in a child's life is best. So what would be some reasons why your legitimation petition wouldn't be granted? Long-term incarceration, severe mental health issues that really prevent you from functioning in society. Very, very high standard.
Okay. So I can see that being very intimidating for somebody that came up and said, I just want to see my kid. I want to see my kid. So is there a process where if we both agree, can we go down to the courthouse? Is there some paperwork we can fill out? Is there a special organization there that can help us do that? I mean, where can we go to get help if we want to do that?
One great resource is FultonFamilyDivision.com.
Okay.
They have put up pro se forms that are excellent for legitimation, consent legitimation, and they have a checklist.
So what do you mean by pro se?
Pro se means you are representing yourself.
Okay.
You do not have a lawyer. Another thing I want to share, it's called Fulton Family Division, referring to Fulton County, Georgia, but the forms have been approved by the Council of Judges. They can be used in any county in Georgia and be valid.
So if I go to my county superior court, I should be able to find something comparable. I don't live in Fulton.
Especially if you're in the rural counties, they don't have as advanced a website. They don't have the same budget that Fulton County does. So what I would encourage you to do is go to fultonfamilydivision.com and print it out and just take it into your local courthouse. They will be accepted.
Oh, that's good.
But it will say Fulton County on it?
You cross that out and write Houston or Franklin or whatever else. I think now they're blank where the county is.
And are you working on some educational measures in that vein as well, Miss Ritchie?
Yes, I actually have a website, or actually I'm working on a website, but I have a Facebook group that's called Kids Need Dads Too, and I also have a meetup.com. And I've been trying to encourage people in the Cobb County area to take advantage of the pro se clinics that they hold at the Superior Court there. I believe it's like every other month that they do one. And they actually go through the whole legal process with them.
Okay. And Ms. Ritchie brought up a very good point a couple of minutes ago when she said that a mother passed.
Yes.
How important is it for them to name legal guardians? Or
Exceptionally important. That's how you direct your wishes for what would happen with your child if you weren't here. It's incredibly important.
So what are the major consequences, kind of just bring it home to the individuals that are out there, of not going through the legitimation process when I was unwed and had a child with someone?
The consequences are as serious as they can get. It means you don't have a legal relationship with your child. It means if you were to pass and leave an estate, that child wouldn't receive any part of it. It means if you were to pass and you hadn't legitimated, your mother, your father, your extended family doesn't have any legal relationship with that child.
I've been paying child support since the baby came out. I was there. I cut the cord.
And the law doesn't recognize cutting the cord or having a name on a birth certificate. You have to legitimate.
So me putting it on the birth certificate is not enough to legitimate the child?
No. Now, there is a newer process in Georgia, and it's being tested. There is a way to acknowledge legitimacy in the hospital. But it is not the birth certificate form. It's another form that the lady who meets you at the hospital from Vital Records can provide you. But it's spotty. I've heard folks who had their babies at Grady. Some of them got the form and some did not.
Wow.
So you have to ask for it. There is a place to acknowledge it in the hospital, but very, very few people are getting the form and doing it properly.
So what's the premise behind my being able to be made to pay child support but not having legal rights to the child?
The premise is we look out for the best interest of children. The state is not all that concerned with the best interest of adults. So when the child comes into being, it has a right to be supported by both parents. However, it's not necessarily in the child's best interest to have a dad who doesn't want to be a part of that child's life having a legal right to the child. So you got to raise your hand and step up and take on that obligation. There are some constitutional law issues that also come into it. Our right to enjoy our children is protected by the Constitution, but you do sometimes have to take that extra step.
So what if I have a question about paternity of that child? What are my options for that?
We were talking about abandonment a minute ago.
Yes.
If somebody accuses you of abandoning your child, you get to say, I would like a paternity test.
Okay, does that stop that whole abandonment proceeding?
It pauses it while the testing's done. And if you're not the dad, you're correct. That ends that abandonment process. You can't be obligated for a child you're either not biologically or legally related to. Paternity can also come up in the legitimation context. You can file the petition and also say, I think I'm the dad of this particular little person, but I'm not certain, and I'd like to be tested before we complete the process.
That's an interesting concept. So could the mother say, I'm not going to have my child tested for paternity, but I still want you to pay child support?
Not particularly, no. That'll catch up to her. Child support enforcement also allows for a paternity testing process. The way child support enforcement has been handling it is if you're a dad and you ask for it and you are not the father, the state or mom will be obligated to pay for the testing. If you are the father, you'll pay for the testing. But it keeps getting cheaper and cheaper to do the testing.
Yeah, because I can remember it being as simple as like $195 and
Correct.
we can swab everybody and be done with it. So in the paternity testing, some people scared of needles. So can we have the option of doing the swab?
The cheek swab, yes. Oh, and they have those kits now at pharmacies to mail away if that's something you and your ex want to do privately before you begin the child support process or the legitimation process. You sure can.
So I don't have to have the mother's permission to get a paternity test for this child?
No. And the court, I mean, if she really won't take the little person in to get their cheek swab, the court will order it and essentially issue a bench warrant if she fails to.
Okay.
It's rare that somebody really puts up that much of a fuss.
Okay, so this show is all about resources, and we're getting toward the end. It's been a wonderful conversation with you ladies. Tell us where we can go and get some help. Where can we find Kids Need Dads Too? Where can I find information about legitimation and all of that?
Well, and you can find me on Facebook, Kids Need Dads Too, and then we have the meetup.com. And we also have started a support group at North Star Church every Wednesday.
Okay. So
not every Wednesday, every third Tuesday.
So would they be able to find information on your Facebook page?
Correct.
Okay. And Monica, could you tell us where we can find some resources? I can get some more information. And, I have a kid and I need to know about custody and child support and legitimation. So, where can I go get some more information?
Some great information. Again, information and forms is at FultonFamilyDivision.com. Again, good throughout the state. You can also check out my website, some good links from HFFamilyLaw.com. And I think we found a great calculator, the state calculator for child support at GeorgiaCourts.org.
And we put that one on our website at youandthelawtoday.org. So if you're curious about how much child support your child should be receiving, that's a good way for you to get your initial information and contact someone that can actually get you into court and get the support that child needs. Well, we're at the end of this show, ladies. I want to thank you so much for coming out. Y'all have to come back and see me again.
Will do. This was fun.
Oh,
Thank
great.
you.
And thank you for all that great information that you gave to the public. Remember, you can get more information at youandthelawtoday.org. You can find Ms. Freitag at, say that, your website again?
HF, like Hanrahan Freitag, FamilyLaw.com.
And you can find Ms. Ritchie
on Facebook at Kids Need Dads Too.
Okay, and remember that you Legally Speaking shows every Sunday night at 6, and we bring new and informative informational shows to you. But in the meantime, and until next time, remember, with every right comes responsibility. So know your rights, accept your responsibilities. We'll see you next week.